Get ahead of what's next with LawPay. While you roll up your sleeves for the next case, LawPay keeps you buttoned down with billing and payments. Secure your payment process, speed up collections, and ensure IOLTA compliance, all while freeing your time and resources to focus on what really matters, your clients. Whatever comes next, LawPay's trusted solution can help you ensure unparalleled productivity, profitability, and client satisfaction. DC Bar members sign up for LawPay today and receive a special offer. Let the 2024 Legal Buyer's Guide help you prepare for what's next in the legal industry. Explore the transformative power of AI and 8 essential technologies you can leverage to empower your team, enhance client interactions, and drive profit. Highlighting key features and providing expert insight, My Case offers a comprehensive roadmap to the best SaaS options. But this guide goes beyond simply shopping for software. It's your blueprint for success. Learn what to consider before taking the leap in order to unlock the full potential of legal technology. Download your copy today.
Welcome, everybody, to the DC Bar's podcast series, Brief Encounters. I'm Michelle Heisner, a partner at Baker McKenzie specializing in mergers and acquisitions. I'm here today with Jim Zukin to talk about financial projections in the wake of the final SPAC rules that have recently come out. Jim, I think it would be most helpful and maybe most interesting to our audience if you could give a brief background as to yourself and how you really got involved in de-SPAC projections.
Thank you, Michelle. Looking forward to our dialogue here on the podcast. And thank you for inviting me to join you. In terms of my own background, I am the co-founder of Houlihan Lokey, a very prominent investment bank that is primarily focused on financial valuation, M&A, and financial restructuring. And so that is indeed my background as well. After a almost 40-year career at Houlihan Lokey, I retired from Houlihan Lokey, created and built a family office that invested in closely held companies, as well as other investments. And through times, the portfolio evolved and those companies needed advice. And so 5 years ago, we spun out Zukin Partners, which is a M&A focused boutique investment bank. And then 2 years ago, we were approached by a number of leading law firms, leading in M&A and leading in the SPAC world, who shared with us the fact that there was a potential void in the marketplace. And the void was that SPACs did not have external third-party expert guidance as to projections, that the SEC had a very clear view that projections need to have a reasonable basis, and that originally in the proposed rules, they talked about the need for an independent expert that would provide a conclusion as to the reasonable basis of projections that would be filed in an S4 or in another document during the de-SPAC process. And the reason that I was approached by a number of these law firms was they thought we were in a good position to provide this service. And quite frankly, I was very excited because of the fact that my own background, much of it for the first 10 years of the evolution of Houlihan Lokey, then Houlihan Lokey, Howard and Zukin, was in financial valuation. The two most prominent services were fairness opinion and solvency opinion, and the modern versions of those were actually created by Houlihan Lokey and a few others. When you take a look at those services, what you see is that they have a number of factors, but a critical factor in both are projections. Projections, when you perform a discounted cash flow, is an important indication of value. And solvency, you have a requirement that the projected cash flow covers the payment of principal and interest that is due under the loan agreements. And so I have had, and my colleagues with me at Zukin Partners and our subsidiary, Zukin Certification Services, a special purpose subsidiary that only performs the reasonable basis review of projection reports that we provide is so we are uniquely capable, we would say, at providing this service. Though I will mention that, of course, there are many, many others in the valuation and investment banking field that could provide the service, assuming that they got up to speed, understood it, and put in the time and effort to introduce it, bring it to market.
It's very interesting. And I think, a lot of people are familiar with fairness opinions and obviously perhaps not as familiar with this reasonable basis review. I was just wondering if you could go a little bit further for the audience who may not be as well versed on what exactly someone's getting when they get the fairness opinion versus what they're getting when they get a reasonable basis review.
When you get a fairness opinion, quote, fair from a financial point of view, you have behind it, a very important thorough analysis, history and nature of the company, projections, of course, and a significant amount of due diligence to understand the company and the industry that it is in. It is an opinion, meaning it is a third party formal opinion as to fairness. Because of that, there is what I'll call a dynamic tension between the client and the provider. And the provider stands apart, reviews the transaction as proposed, and either is able to opine as to its fairness, or in some cases may have an issue, and that issue will then need to be hashed out. The primary approaches to a fairness opinion are market approaches and the discounted cash flow. First, to the market approaches. These are done in a variety of ways and a variety of measures of cash flow, profits, etc. However, in today's marketplace, they are principally using two approaches. One is to develop a ratio, which is the price to EBITDA taken from relevant transactions, not going too far back, of companies in the same or similar industries as to the subject company, and that they are then, in developing this ratio from those comparable companies, that ratio or range of ratios are applied to the subject company. Oftentimes, the application is to EBITDA for the trailing 12 months, the previous year, current year, projected years, and there's a judgment made. And the judgment is made is what is a representative EBITDA. Once that is determined, then there are these two related approaches. One is taking public company comparables and applying their ratios to the subject company's EBITDA as determined. And the other relates to transactions, M&A transactions, to the extent you can get this information from the financial sources to then apply a ratio to the subject company's EBITDA. In addition, we have, importantly, using the projections, understanding the projections. Projections are prepared by management. They are not prepared collaboratively. Again, Chinese curtain. And so after understanding the projections, then a discount rate is developed, and using classic financial techniques like they teach in business school and that you are trained upon when you are joining a firm. And so you end up with the discount rate. In some cases, you will have a matrix of a few different discount rates, and then you will bring that to the present value. That is the present value of cash flow, and that is an indication of value. In doing this, by the way, oftentimes the subject companies are put into a cash-free, debt-free, with reasonable working capital adjustment so that you can compare companies of various different leverage with your analytics that you develop. And so that becomes what I'll call an important nuance. And so in doing these, when you take it all together, you have a fairness opinion. And then we go to the reasonable basis review. The reasonable basis review is not an opinion, it's a conclusion. It includes a consultative review of the projections. When I say the projections, I'm talking about the start is the assumptions. For the assumptions, we are looking for analytics, talk about the basis, talk about top down. What is the market and what will be related markets in the future for the company's goods and services? And so we talk about TAM, SAM, SUN, which is the addressable market in general, total addressable market, TAM. And then people take it down further and say, out of that TAM, what is really available? And then once you have that on the top down, you have a sense of the market or markets themselves. Then there is the bottom up. It is in the bottom up where the expert that is developing the RBR analysis really gets to work because of the fact that can the company itself achieve these projections? Are the projections trended from historical? Do they take into account the use of the expected capital that will come out of the SPAC process? And so all of the assumptions, and by the way, I want to stress this, the assumptions are provided in detail by management to the provider, the expert of the RBR conclusions. And because it is consultative, in our case, we also make sure that the assumptions are actually translated into the projections. We even double check because sometimes we actually find errors, just mathematical errors out of cells and whatnot. Not that we're perfect, but on occasion, we do find some errors that may be material. And so I say consultative because of the fact that sometimes our input is such that our clients choose to modify their projections to take into account certain factors they may have not considered. And so it does have a value for that reason. Also, in terms of the service itself, oftentimes there is very little information that is provided by SPACs at de-SPAC. And at de-SPAC, when you have the RBR, in particular, if you choose to have and file a report, you have some significant information that, unlike an investor's presentation, is straightforward, factual. It's not selling, it is describing and analyzing. So that's a bit of an overview of the difference between fairness and reasonableness in RBR.
And so it seems like forecasts are really pivotal to everything, both to determining whether a transaction is fair and also, I guess, the SEC's scrutiny of the projections that are provided. So would it be helpful, Jim, if I went through how the SEC has traditionally approached projections?
Michelle, I was about to ask you that question. I think it would be very important for our listeners to have you hold forth on that important point.
Yeah, so I think that it's really important to take a historical view of this. And it's helpful to go back 30 years to the adoption of the Private Securities Litigation Reform Act of 1995. And you think about the context of that and the fact that, for years, really, the SEC and Congress had been looking at the fact that projections were not being disclosed by issuers, but they were viewed as being, helpful in determining a company's valuation and something that a reasonable investor would, in fact, be interested in. But companies were not filing those projections. They were not disclosing those projections because of fear that there would be litigation in the event that those projections were not met. So in 1995, the PSLRA aimed to eradicate a wide swath of litigation practices that many considered to be abusive at the time, that, among other things, were inhibiting the dissemination of projections. And really, the innovation of the PSLRA was that it shielded companies from liabilities if the statements that they made were, one, made with meaningful cautionary language, and two, that the person making the statement did not have actual knowledge that the statements were incorrect.
But isn't there a difference between how disclosure of projections was approached in M&A transactions versus IPOs?
Yeah. So it was for M&A, in PSL, the PSLRA said that a company could only be held liable for missing projections if it knew that the projections that it was giving were wrong. And further, if you think about it, in M&A transactions, reporting companies, they often are actually required to disclose the projections that they're using. So under Delaware law, when a public company's board of directors is considering and analyzing a strategic transaction, financial projections are typically a significant component of that process. They play really an important role in the board's exercise of its fiduciary duty of care, in large part because they reflect what the management team's best judgments are about the future performance of the target's business, and therefore the valuation for that buy-sell analysis. And under Delaware law, when the directors are seeking stockholder approval for an action, and you often see in an M&A transaction, they also have a duty of disclosure, which is derivative of that duty of care, and a duty of loyalty. And they have to make full and fair disclosure to their stockholders. So if a board of directors relies on management projections when they're approving an M&A transaction and recommending it to their stockholders, then those management projections are typically viewed as being material and necessary to disclose under the standard. And also, as you were talking about, the projections can form a basis for that fairness opinion that the board's getting and relying upon. And so, if the financial advisor is using those management projections in order to render its fairness opinion, they're considered to be material and something that the stockholders should be seeing. And so with the Securities Exchange Commission, with the SEC, while there's no specific regulatory requirement to include the financial projections, it's established practice for the SEC staff to ask for their inclusion on the basis that they are material. You compare that to IPOs. And specifically, IPOs were excluded from the safe harbor that was provided by the PSLRA. And perhaps unsurprisingly, you don't see in a traditional IPO and a traditional underwritten IPO projections being included. There's no prohibition on including the projections, but the reality is that people probably consider that the liability risk associated with including projections when the PSLRA is not there is just too high.
How did de-SPACs fit into the regulatory regime? And what exactly did the SEC's rules released in January of this year change when it comes to financial projections?
So, the issue with the de-SPAC is that it's kind of neither fish nor fowl, right? And that's what you see when the SEC, released its final rule, is people trying to decide what regime should be applying. Should the M&A regime be applying? The M&A disclosure regime be applying? Should the IPO disclosure regime be applying? And, initially during the de-SPAC boom, well, I guess actually I'll take a step back for a moment and just say that why is it neither fish nor fowl for people that are not, involved in the de-SPAC market? It's neither fish nor fowl because it's really a mechanism for the target company of that business combination to list itself. So it's an initial public offering in that sense. But the mechanism by which they list themselves is via essentially an M&A transaction. So a publicly listed company, goes out and seeks, and that publicly listed company has no, assets other than the cash it has raised specifically for the purpose of acquiring a target. So that's why it's really a hybrid transaction. And therefore, initially during the de-SPAC boom in 2021, what we saw was that projections were being sort of widely disseminated, I would say, in both, the pipes that were being raised alongside to raise cash in these de-SPAC transactions, and they were also being included in proxy statements. But that really started to chill, I would say long before the final rules on SPACs were disseminated in the US. Really, I think the first sort of tolling bell was when SEC Commissioner John Coates made statements in the fall of 2021 questioning the PSLRA's safe harbor for forward-looking statements and their applicability of that safe harbor to de-SPAC transactions. So, I think the final rule ultimately was cementing what the market saw coming in terms of de-SPACs. And it really had two principal areas that it was looking at. The first was disclosure. It put in enhanced disclosure that really had been developing in response to SEC comments that were coming through in the years from 2021 forward that we were seeing. And the first is kind of a set of disclosure rules that are applicable to all projections. So not just in de-SPAC transactions, but all transactions. And they're sort of just general that projections that are not based on historical results need to be clearly distinguished from projections that are based on historical results. And that projections that include non-GAAP financial measures include a clear definition of those measures. And then there were specific rules that were applicable to de-SPAC transactions and the disclosure of their projections. The SPACs needed to disclose the purpose for which the financial projections were prepared and the party who prepared the projections. They need to disclose the material assumptions underlying the projections, including any material growth rates. And I think this is really interesting. The final rules required a statement as to whether or not the projections reflect the view of management or the SPAC or the target company as of the most recent practical date prior to the disclosure documents of the proxy statement being disseminated to security holders. And that's really interesting because the whole basis for why the projections are included is because they are what the board considered. And with a de-SPAC transaction, given how long we've seen these things sitting in the market, it's not a bring down of the projections, but it is a statement as to whether there's still the view of management, maybe like a year or so after, when many intervening events could have happened. And the second prong is liability, obviously. And this really, I think, is where Jim and I guess the focus on the reasonable basis review comes in. So the SEC explicitly made unavailable that PSLRA safe harbor for forward-looking statements in SEC filings. And they returned to that focus of there being a reasonable basis for projections. You can see that in the disclosure standard, there's references to the reasonable basis. But then also, if you think about this in the context of what is the liability regime that applies to issuers now? Well, one, you've got the bespeaks caution doctrine, which you can see in court law and I guess in 27A of the Securities Act, which is a doctrine that you can, essentially you need to be qualifying the statements you make in projections, forward-looking statements with adequate cautionary language. And then the second is Rule 175, which is a rule that was enacted, prior to the PSLRA, which provided a safeguard for projections. So you weren't liable simply because you missed a projection. A company was not liable simply because it did not achieve the projection, but rather only if, for at least certain statements that are covered by Rule 175, if they were made without a reasonable basis or in bad faith. I guess the interesting thing here is that in practical reality, what you saw in, back when Rule 175 was adopted was that it did not actually succeed in encouraging projections really to be fully, disclosed by issuers. And that was why the PSLRA had to be enacted in the first instance. That's sort of the legal framework of what the SEC was doing with its new SPAC rules and in terms of projections. But Jim, I'm wondering what stuck out to you about the final SPAC rules.
The final SPAC rules made it clear that the RBR conclusions, reasonable basis review, analysis, and the conclusions that the projections are reasonable went from a nice to have best practice to a important, if not critical to have. An example in terms of market reception. Over the last 2 years that we have been performing this service, we actually introduced it a bit before the preliminary rules were released, was we have done a handful up until the time of the final rules. Today, we have a true backlog, though we haven't done any significant marketing other than contact the folks that we work with. And so there is a clear market response to these. And I think that relates to the fact that management prepares and in essence provides a reasonable basis review of their own projections. In essence, they sign off on their projections in a manner similar to signing off on their financial statements. So now let's go to these specific rules. What is the name of the rules? These are the SEC SPAC projection rules. The rules mention projections over 450 times. It is a true hot button, and I think by the messaging, it is clear that management and sponsors are advised to get an expert third-party review. But back to your question, my view, and others more knowledgeable than I have shared this with me, is that these rules are more about guidance. So there is nothing that I am aware of in the rules that say you need to go out and get an RBR from a third-party expert because they are guidance. And that would be my view about what stuck out.
But I don't think, can you unpack that a little bit? Because I don't think the rules, like as adopted at least, the final rules say that an expert's required.
No, I'm saying the opposite. I am saying that in the, may I call them preliminary rules?
Mm-hmm.
They have a section that talks about the expert and the qualifications of the expert and the fact that the expert would need to give permission to have their report, which they called for, filed in a public filing, etc. Now, that level of detail, I do not recall being in the final rules. So I am not saying that they called for it in that sense. What I am saying is that there is clarity, general clarity, that management provides the filing of their projections and assumptions. They are signing off on them, just like they sign off on financial statements. And so oftentimes, if you have a painting and it's a beautiful painting, it's a fantastic painting, and you've done this painting, well, you can say it's beautiful, but it probably, in terms of the marketplace for paintings, the buyers of painting, the galleries and whatnot, they are going to look to the view of experts in the field who indeed say that is an extraordinary painting or whatever they would say. Now, this may seem to you be kind of an odd analogy, but what I am saying is that an expert third-party review may be very important for a sponsor, for management, for their legal and financial advisors, that they have this perspective because of the importance of projections. When a company de-SPACs, oftentimes there's very little information. How does a, say, retail investor in particular get a handle on it? Is there a independent review? Is there a report that goes into significant detail? Our reports that have been filed are 15 to 20 pages of content relating to history, nature of the company, the assumptions, and the projections with a conclusion. And by the way, our conclusions specifically state that we find, assuming we do, of course, the assumptions to be reasonable. And furthermore, we find the projections to be reasonable. Again, these are conclusions. That is much different than an opinion. And also, the service itself, as I mentioned previously, is consultative. And therefore, we interact with the client, going through assumptions, questioning assumptions, and indeed, those assumptions may change. I want to underscore the fact these are their projections. They are not ours.
Yeah, and I guess, like, not to jump ahead, but from my perspective, this all just, it ties back to this liability regime that not just the SPAC, but the target company, which not only inherits the SPAC's potential liabilities, but is now co-registrant under these proposed rules with the filings. That liability regime, which again, the SEC was focused on having a reasonable basis for these opinions, and also on the safe harbor for reasonable basis under Rule 175. So that's the focus. And I think that we see it to the extent that we see, we've been seeing, I think, as lawyers for several months now, that many of the SEC's comments have really been focused on the projections over the last several months. And one of the areas that they're focused on are the assumptions. Are the assumptions reasonable? What are the assumptions? Are the assumptions fully disclosed? Do the assumptions remain valid? Why or why not, in light of this, that, or the other, sort of actual operating performance that's being disclosed in the months that may, be happening in between signing and closing? So I guess with that in mind, have you seen people come to you then in light of these rules asking, like, what do you normally tell them about how this can help issuers and their targets in the SPAC process, the de-SPAC process?
The main way that we address that is by describing to them what we do. Also, what we have found and others is that in the negotiation today, the process of negotiation for a SPAC, for the valuation, for the pricing, that it is rare indeed for an operating company target to not put forward its projections, to not negotiate on the basis of those projections. And it is also very, very common for the sponsor who is raising additional PIPE, et cetera, capital to disclose those projections to a group of institutional investors. Once that happens, then as I understand it, those projections need to be shared in a public filing. And then once that happens, there is, and you are absolutely right, the centerpiece of our work is the analysis of the assumption and their translation into the projections. You talk about co-registrant, and I defer to you. Of course, that's very much a legal term, and I do understand it. But perhaps as being co-registrant, it goes back to what I said about signing off on the projections. But I will say to you that the people and their lawyers, that oftentimes is their lawyers that are coming to us, ask us what we think about them, the target company being called a prospect for our service. And we say it needs to be an operating company. It may have revenues that are beginning now. And that's not typical, but we have one specifically, a major company like that, that's like 7 years old, but now based on solid contracts, is beginning to ship very large volumes of their product. But that would be an exception. For the most part, and the SEC mentioned this in the preliminary rules, there is a historical basis that should be trended. And then you can describe the trending. Again, the trending may be having access to capital, having new acquisitions that are in mind, having new products, etc. And so I think that may address what you're talking about. But one last comment, and that is those companies for who it may not be a relevant service. I had somebody come to me and said they had a molecule. The molecule was worth $1 billion. It was going to cure cancer. I said, I thought that was great. It was amazing. And I hope I never get the cancer that it will cure. But in the meantime, the projections were highly speculative. And of course, they're really talking about the addressable market. Okay. It's really more of a top down, but regardless, told them that we did not think it was a candidate for our service. So I think the service is focused on operating companies.
And I think that time is going to tell. I mean, from my perspective, I think time will tell how the market reacts to these rules and what they do with projections. And frankly, we'll see if we have another wave of de-SPACs as an alternative to the IPO, traditional IPO. But there's a fundamental tension, right? I mean, like you cannot simply, just because there's a liability exposure, say, well, we'll just not have projections when the fundamental nature of a de-SPAC transaction has this M&A component. So there is like a need to essentially set a price. I'm air quoting price, but it's the valuation of the target that determines how many shares are issued and the amount of dilution that's essentially happening to the existing SPAC shareholders. So that, I think, is the needle that needs to be threaded by issuers.
I would agree with you on that. And a closing comment from my perspective for the work that we do is to highlight the fact that we do not do evaluation. We do not perform an analysis of a present value of projections or support in that manner. What our service is, it is very narrow. It is just on the projections themselves. And they are, again, a component of a discounted cash flow, which is an indicator of value alongside the other indicators I mentioned previously. And so, regardless of the valuation that may come out of the work that is done by the company as confirmed by the fairness opinion provider, what we do is very narrow. And it is a conclusion based on the assumptions and the projections only.
Thank you, Jim. This is a weighty topic to be dealing with that, we could go probably hours on, but I really thank you for your time, and listeners can tune in for the next episode of Brief Encounters.
Thank you. I've really enjoyed participating in this discussion with you, Michelle, and look forward to hearing from any listeners should they have any questions.
This episode of Brief Encounters was brought to you in part by our sponsors LawPay and MyCase. Find out how these solutions can work for you by visiting lawpay.com and mycase.com. For more information, check out the description of this episode.